Greetings, campers, and welcome to the latest installment of our TELUS webinar series. My name is Scott Walker. I am the Executive Director of the Canadian Artists Network, formerly known as CSAR, the organization formerly known as CSAR. It's a pleasure to welcome artists today from across Canada to our webinar. And I would like to begin by acknowledging that we live, work, and create on the traditional territories of Indigenous peoples who have cared for this land, now called Canada, since time immemorial. We acknowledge this as part of our covenant with all Indigenous nations to share, respect, and protect the land in the spirit of peace and friendship, to honor the future generations of all our nations. I know that we have several artists here today who may not know about the Canadian Artists Network or even in our former incarnation of CSAR. And so I'd like to take a couple of minutes to correct that, if I may. The Canadian Artists Network, formerly known as CSAR, engages experienced professional artists of all disciplines as they continue their work as creators in the visual and performing arts, through the written word, as well as on production teams. As the voice of Canada's elder artists, we offer a suite of programs and services to inspire, assist, and encourage veteran artists to continue creating for themselves and for all of us. Our longest running initiative is our mentoring program. It is now in its 10th year. We have facilitated more than 100 mentorships involving more than 300 artists, and we are pleased to welcome TD Ready Commitment as our newest sponsor, joining Power Corporation of Canada. This is a set of images of just some of our incredible mentors. And this is a small sample of the works that have been created with the guidance of and financial support of the Canadian Artists Network and our mentors. Veteran artists tell us they want to keep honing their skills, so we began presenting Maintaining Creativity in 2016, an annual conference that brings together elder artists for sessions of discussion and discovery with many well-known presenters. Last fall, we presented Maintaining Creativity 7 in 3 two-hour chapters that brought together artists from Belle Isle, Newfoundland to Bowen Island, BC. Our keynote speaker was the Right Honorable Michaëlle Jean, former Governor General of Canada, who is a strong believer in the power of the arts. Other headliners included Globe and Mail columnist John Ibbitson, musician Nikita Carter, visual artist Vera Frankel, opera star Ben Heppner, a Real World founder and Canadian Artists Network board member Tanya Williams, and actor and former MP Lenore Zann. Videos of all 3 chapters, by the way, along with Maintaining Creativity 1 through 6, are available on our website. And we're happy to report that Maintaining Creativity 8 will be presented this fall. Our online salons or on-salons give artists an opportunity to get together virtually to talk about issues and share ideas. Since many artists work in isolation, the on-salons are a reminder that you are not alone, that in fact you have a national network of like-minded colleagues. We present webinars such as this one on a variety of topics, including social media. We have one of those coming up next month, publicity, copyright, healthcare, wellness, and finances and legacy. We also have a Healthcare Assist and Connect program that offers advice on a range of healthcare issues. And by the way, all of our programs are free. We present our Robert Johnson Visionary Artist Lifetime Award is given annually to an unsung hero in the arts. Last fall, we presented the 4th annual award to Terrell McGuire, a dancer, teacher, and mentor. All of this is made possible because of the corporations and organizations and individuals who believe in what we do and help us to be the voice of Canada's experienced artists. Many elder artists tell us that they worry about their futures as they age, but they also tell us they intend to continue living their lives with what one called ferocious intent, creating, helping to build Canada's economy, and making this a richer and more vibrant country in which to live. And we thank you for being part of this journey. We're calling today's webinar A Place to Leave Your Stuff. preparing and preserving your artistic legacy. We can all relate to having a place or needing a place to keep your stuff, especially those of us in the arts. You know, we've got a lot of stuff and it's due to our creative lives. So that's likely why you are here today, because we need to figure out what to do with our stuff when we no longer have any use for it. I'm going to try to answer some of your concerns about what to do with your artistic stuff today. We'll be talking about the legal side of things. Next week, a week from today at the same time, we are going to be talking about archiving. We'll do a deep dive into archiving, as they say, including digital preservation. So we're going to begin with a look at wills and such. Our first expert is Director of Legal Services at AFBS, the insurance and retirement savings provider to Canada's screenwriters and performers. He practiced general litigation and estate law for 11 years, worked for several national banks. His work at AFBS includes overseeing legal issues related to estate administration. He is an emphatic advocate for effective estate planning. Please welcome Kevin Forrest.
Thank you very much, Scott. Thank you very much, everyone today. It's a real pleasure to have been invited by your host organizations and personally also a real delight to work with Scott and to be here today to run you through a few high points of estate planning and preparation. I believe Scott is going to assist me by overseeing a slide deck that I've prepared. Now, I don't want to make this too lawyer-directed a chat. I'll sort of lay out here a few of the essential terms and some broad understanding of what estate planning is all about and the different ways that people may go about it. And then we'll have more time at the end after Paul Bain's presentation to take some general questions. So I've referred to this as clear as mud, wills, powers, and attorneys, and all that. This is an area that no one particularly likes talking about. There are certain complexities to it, which make it difficult to understand both for many general practitioners or lawyers who are not involved in this space all the time, and also for lay people. So there, as we say, are no dumb questions, and nobody should feel that they are unusual if they have a knowledge gap at any point in their understanding of this. We'll try and get through things and point you in the right directions at least. May I have the next slide, please? This is always a fun one. I leave this up here for you to read at your leisure. Basically, what we're saying is that I'm providing this today for informational purposes. It's not legal advice, nothing I do, and no interaction that we will have as a result of this presentation today represents legal advice. I am an Ontario licensed lawyer. I will be speaking in any specifics today only from the perspective of Ontario law. It's important for us to remember that in Canada in particular, estates law is generally speaking governed by provincial law. So rules may differ from province to province, and I am in Ontario. So I won't detain you any longer on the legal ramifications, and we can move on from this slide, please, Mr. Walker. So a very quick agenda just to keep us on track today. First point, I refer to as voices off stage, wills, estates, and beneficiary designations. Number two, we're going to talk about the live show. So those are the powers of attorneys, delegations, and authorizations that you may engage in substitute decision planning as you're going through. Those are not specifically estate matters or related to wills or to a place to leave your stuff after you're leaving the stage. But I think it's important to just sort of touch on them because they're very important documents and they're usually discussed in the context of any estate planning discussions. Third, break a leg, getting on with the show, the actual getting up and doing of the final planning and some tips and points to remember about that. And the curtain call at the end are 5 key takeaways, 5 things to remember. So we'll move through this relatively quickly today. And as I say, I'll provide good fodder for some questions in the Q&A session at the end. Next slide, please. Yeah, we can skip by this one, my title card. So it all starts, we hope, with a will. So just some terms to sort of get us all in the same square. Wills are documents that we're all sort of generally familiar with. They actually speak from the moment of death. They tell us who will manage your business affairs after death and what will be done with your property. So these are an opportunity for people to actually determine what will happen to their stuff and who will look after managing those affairs as of the moment they pass away. I mention that and emphasize that because sometimes there's some confusion about this idea of what we used to call probate. And often people have the mistaken belief that probate is somehow necessary to effectuate a will. That's not true. A will can be effectuated without probate. Probate is a court process which actually protects third parties. It is something which is very useful. It's often required by parties in an estate matter, but it is not necessarily essential. And indeed, many wills are distributed. Many final wishes are given effect to without the benefit of probate or without the requirement of probate. So I just point that out. Beneficiary designations are a little bit different. They also speak from the moment of death, but they don't actually make any appointment or confer any power of a beneficiary on any person to act for your estate. So when you make a beneficiary designation, as people do every day in my place of work here at AFPS, they'll leave a beneficiary on their registered accounts or on their insurance policy. And that simply means that that person will be paid monies upon the death of the donor. So it's they're similar but quite different, and we'll talk about that a little bit more as we move on. Just a few other high points on to the right there. I think they're self-explanatory. I don't want to take a lot of time about them, but just again, the difference between a testate succession and an intestate succession is sometimes important because some people say, oh, well, I don't have to make a will because everything will go out on intestacy. The government will look after when I'm gone. True, but maybe not desirable. And just a few other bits and pieces there, which I encourage you to look at your leisure. Next slide, please. So, as lawyers, we talk about the formalities of a will. Wills, as you can imagine, have grown up within the context of common law equity over about 1,000 years, and there are certain principles which might seem a little bit anachronistic or historical, which are still sort of clung to in the space of a will. So the essential formalities of making a will are relatively simple, but they're important. A will has to be in writing. It has to be signed at the end by the deceased, who is known in this context as the testator, or by an amanuensis, which is basically a person who's writing on behalf of someone who cannot. And if the amanuensis has done that, it has to be done under the testator's direction. So it can't be done separately. The document must be signed by 2 witnesses who actually saw the testator sign the will or saw the testator acknowledge his previously or her previously signed signature. This is an important point because sometimes people say, oh, well, I don't know what I'm going to do about getting the will signed because I don't want them to know the contents of my will. Witnesses to your will never have to see the document. All they have to be able to do is see that you saw the document and that you signed it. They're witnesses to the signature, not the document. And the last point there about formalities is that beneficiaries, so people who are going to receive something under the will, or trustees, so those are people who might be colloquially referred to as executors or personal representatives, anyone who's receiving a power of appointment under the will should not be witnesses to the will. And the reason for that may be somewhat self-explanatory. Beneficiaries and trustees could be accused of benefiting from a document that you're signing. So it's just better for the defense of the document that they not be parties to the formalities. On very rare exceptions, there are the law does provide exceptions for wills that don't meet these requirements, and in particular factual circumstances, the will would still be valid. I don't want to detail them for you. They are quite extraordinary, but one of them that you may encounter is what we call a holograph will. A holograph will is a special kind of will which doesn't need to be witnessed. It doesn't need to meet all of the formalities. It is a document, however, that is entirely written in the testator's handwriting. So it can't be typed and signed by the testator. It can't be prepared independently. It can't be left partly witnessed, partly printed, partly signed. There are very strict rules around it. And again, they're quite extraordinary, and it's meant to be a remedy in an extraordinary factual circumstance, like someone is trapped under a car and they're able to write something as their life ebbs from them. They're not things you plan for. So I mention that only that you're aware, but we try to avoid these situations wherever possible. An important tip here that I do want to point out is that a will typically includes various sections which appoint representatives. They give away certain property, and they'll also usually revoke previous documents which purported to appoint or give away property. Generally speaking, wills include a revocation clause that says, I hereby revoke all wills, testamentary dispositions, and codicils previously made by me. However, you should be very mindful that if you have certain types of property, such as registered retirement income funds or RRSPs or insurance policies, those dispositions are not usually revoked by subsequent wills unless you specifically name them and specifically revoke them in your will. So beneficiary designations on certain types of property previously made will survive a will. So that's something that must be borne in mind when you're thinking about and talking with your advisors about will preparation. Next slide, please. And again, I would note, provincial law governs in this space. So if you're in basically the English-speaking or common law provinces in Canada, the rules are largely similar, although not identical. And if you're lucky enough to be one of our beloved colleagues in the province of Quebec, of course, everything is special in Quebec. And that extends to succession law as well. So much of what I'm saying here today is extremely informational for you and may not be applicable in most circumstances. So generally speaking, we look for people to incorporate wills into their overall estate planning approach. It's a pretty essential and fundamental tool. That being said, it's not the only tool for giving away all property. People may arrange to dispose of certain types of property after their death directly without referring to them in the will or letting them fall into the residue of their estate. And usually this happens through beneficiary designations. So as I've noted there, and I previously mentioned, life insurance policies, many pension benefits, and registered accounts are often give you the opportunity to make a specific beneficiary designation. So you can leave your life insurance payout directly to a named person. That asset would then go to them upon your death. Now, there are tax implications, and there may be control implications, and there may be creditor implications of all of these choices. So it's a relatively complicated space, but it's something that you should be aware of. Other will substitutes, as they're broadly colloquially called, can include joint tenancy on a piece of land or a house. So if you're a joint tenant on your house with a spouse or a child or someone else, there is usually a presumption of advancement in a situation like that, which means that a right of survivorship would come into play. So when you pass away, the other person who remains the joint tenant becomes the sole owner. You can also have joint tenancies, of course, in bank accounts and investment accounts. And there is usually, as I say, a presumption that this was meant to survive your passing, although not always. There are certain circumstances where that presumption will not follow. A key point to remember here, and I emphasize it again, although I did just allude to it, is that assets which pass under will substitutes become the property of the beneficiary or joint holder at the moment of death. They do not become estate assets, so they don't fall into the estate that your will purports to deal with. This may be the intended consequence, or it may be a very unfortunate consequence. Again, careful planning and real thorough understanding of the estate context is necessary. And the second paragraph there says the beneficiary designation is usually arise under a private contract or a particular statute, so there are no universal formalities. I mention that only because you might find that you go to one institution and they want a witness on your beneficiary designation. You may go to another one and they don't care whether you've made there's a witness, or they want two witnesses, or they have to fill out their form, or other places will say, just send me an email. It's all over the place. There is no strict law that governs the formalities the way there is with a will. Please, may I have the next slide? So now we're just briefly going to touch on powers of attorney and delegations. Next slide, please. So powers of attorneys are documents, broadly speaking, which are at the core of what we call delegations of power. They can be very different things, and they can grant very wide powers to people. So in the province of Ontario, we have the Substitute Decisions Act, and it governs documents including powers of attorney for personal care, which authorize persons to make care and health care treatment decisions and end-of-life decisions on behalf of someone who is incapable of doing so. They're often called living wills, but that's a colloquialism. It's not a legal term anywhere that I'm aware of in Canada. Powers of attorney for property are similar, and they are the separate document which authorizes a person to make property and business decisions on behalf of another. Again, they're governed by statute in Ontario. There are certain requisite formalities that go along with the preparation of both of them. There's a whole other class of delegations, which we're not going to get into here today. Authorizations, directions, consents, and you'll encounter them in your business life, but they are documents which allow you to delegate specific responsibilities to specific people for certain circumstances. The important thing to remember here is that they don't arise out of any statute, and they don't delegate any power to make decisions on your behalf. They are basically instructions to other people to let this person act on my behalf in this circumstance. So a very different kind of document. May we move on to the next slide, please? So again, just some terminology. An attorney is a person appointed to act in place of you under a power of attorney. In Ontario, a little sidebar, it's actually prohibited to refer to a lawyer or a solicitor in Ontario as an attorney. We don't use that phrase. It's a Scottish phrase or an American phrase. So when people talk about an attorney, certainly when lawyers talk about attorneys in Ontario, and I think most common law jurisdictions in Canada, they're talking about individuals who have been appointed under a power, not another lawyer. A continuing power of attorney for property typically is a power of attorney which, once granted, continues even if the grantor, so that's the person making it, granting the power, loses mental capacity. This is a very important distinction, because I could make a power of attorney today to delegate my colleague to go and renew my mortgage, and that's the specific purpose of that power of attorney. And when they have discharged that duty, that power of attorney will come to an end. I can do that. I could make a power of attorney for property, which, because I'm going on a worldwide cruise and I need someone to take care of my business while I'm away, and I want them to be treated with full credit as if I were doing it myself. That's very different from a document, which are like the ones we make under the Substitute Decisions Act, which basically say, I'm delegating this person the ability to have discretion over the management of my property on my behalf, even if I lose the capacity to revoke this and I'm no longer capable of doing myself. So very important document. A delegate there I mentioned is just a person who does something on your behalf under another type of document. And a fiduciary obligation, this is a key piece because it rises into this whole question of people being attorneys. Power of attorney documents create fiduciary obligations. A fiduciary obligation is an obligation of the utmost trust, where the person you've appointed is obliged to act in your interest, even in preference to their own interest. So it's a very, very important act which someone is being asked to perform. I've got a few key points there which you can look at later. I don't need to emphasize them about the restrictions and requirements of making a POA. Next slide, please. So getting on with the actual show of final planning. This is a little bit of a sales job and some good home truths from a lawyer who's been practicing in this space for about 20 years and seen lots of things in my previous private practice. Every adult should plan for succession, regardless of age and wealth. We hear this all the time from people who are young, people who have nothing, quote unquote. In my experience, there are very few circumstances where you should not be thinking about succession planning. A lot more problems for a lot more people arise out of situations where plans were not made. And the other piece is your voice does not get heard. Once made, of course, plans and documents need to be reviewed periodically. These are organic documents. This is not a one and done exercise. And I say that with the utmost empathy because I know it's difficult for many of us to embrace it. For the first 45 years of our lives, we say we're too young to do it. And for the next 35 years of our lives, we say we don't want to think about that. The problem with that kind of approach is that we will sometimes take ourselves to the brink and say, okay, I'm going to do it this year. And then we do it. And we think it's frozen in aspic, and our lives change. We have material changes in our life. Our family status changes. We have children. Children pass away, God forbid. People go into different circumstances of relationships. Financial circumstances change dramatically, and the will you made when you were a struggling artist in your 20s no longer reflects reality when you're a successful artist in your 50s or 60s. So get comfortable with the idea of planning for succession and make it an integral and organic part of your life. When making financial arrangements, it's important that you dispose of all your assets. This is a really important key for people in the artistic community who might have all kinds of assets they haven't really sat down and thought hard about. On the financial side, it can be RSPs, RIFs, TFSAs, insurance proceeds, different places. In my own AFBS context, we have insurance reserves which flow in. Artists in performance artists often have residuals. There's real estate, investment accounts. People don't think about these things. And when they're sitting down to make a will, they don't address them. And then sometimes they become lacunae, which are difficult to deal with because they're neither fish nor fowl within the context of the things that have been left behind. So I encourage you to do that. The other thing is all your other stuff, all the personal property, mementos, great Aunt Agnes's diamond bracelets, the picture on the mantelpiece that's been there forever. Those kinds of things may have little or no value. At the end of the day, unlike in the movies where everyone sits down to read the will and it's detailed to the last item, that's not really the way estate distributions work. We tend to leave those things in a hodgepodge, and it's in the discretion of the executor. So unless it has really significant monetary value, so if it isn't already insured for its value, you probably want to not put those things in the will, but it probably makes sense for you to address those things with your executor. The final point, and this sounds self-serving for my colleagues, and if it is, I don't apologize for that, but there's a very good reason for it. And that is that things can get complicated. If I haven't already given you the flavor of that, it's not for want of trying. This is not an easy area of practice from a legal standpoint or a factual or an emotional standpoint. And it's not mandatory for you to hire a lawyer, or if you're in British Columbia or Quebec or some other place that has notaries assist in the production of wills, a notary, to help you with succession planning and preparation. But it is a good idea to get the benefit of their experience, their independence, and their knowledge. costly mistakes can come out of doing this wrong or not doing this at all. And the price of sitting down and going through a proper plan and a proper preparation exercise will probably repay those you care about who are left behind and your legacy over and over again. Next slide, please. So 5 quick things to remember. If I repeat myself a little bit here, it is just because I do want to emphasize these things. As I just mentioned, and I put it first, intentions set out in wills are usually fairly general on purpose to give flexibility to executors to manage your estate. Bills have to be paid as a first charge against an estate. So sometimes estate assets that people would like to leave to, their nephew have to be sold. And so executors have to have that flexibility to act. And the law gives them a fairly wide scope to use their discretion to make decisions to settle estates. So that's a reason why we don't want to itemize every item and who it's going to in our will. However, it may be very helpful to the executor, and I would encourage from my practice experience that if you do have items that have significant monetary value that an executor who's not an expert might not appreciate, or that have deep historical or emotional connections, you may want to itemize them in a separate memorandum and say, hey, I understand you're going to be exercising discretion in the administration of my estate. I've empowered you to do that, but here are some things that I would like you to take under advisement and to handle appropriately if you can. Second point is, when you're choosing executors to appoint under a will or attorneys to act for you if you're incapacitated, remember, they play essential roles, really, really important roles in making sure that you are kept safe and in making sure your legacy and your beneficiaries are kept safe. Make sure that you choose them carefully. Make sure that you trust them and make sure that they understand what you're asking them to do and make sure that they're competent and capable of doing it. And finally, do tell them and do get their okay to act, because the number of times that I've been involved in situations where the first they heard that they were acting as executor of a will was when I called them to say, let's get the administration going because she named you. It's not a huge number, but it's a shockingly high number. And I would just emphasize there, without telling a war story, that the challenge, and I mean, we do it, we all do it. And I did it myself, and I'm not going to change the world by saying that it's probably not a great idea. But one of the other things we do is we make wills and we appoint our spouses or our children as our executors because we trust them. There are many, many cases, and as I say, I'm guilty myself, where this makes a lot of sense. The other thing, though, that we have to be mindful of is this might be the person who is least emotionally equipped in the aftermath of our death to deal with serious business decision-making. So to the extent that that is a factor that you consider, it's sometimes something that you have to give thought to. So it's an important decision, an important thought process. Third point, as long as a person has appropriate legal capacity, and I say appropriate because the legal capacity test for making a will, making a power of attorney for substitute decisions under health, and making a power of attorney for management of property under the Substitute Decisions Act are all different. But as long as the person has the appropriate legal capacity, they can revoke or make a new will, new beneficiary designations, or new powers of attorney at any time. So it's not a one and done exercise. You are free to make changes. Now, there are some statutory change issues with that, obviously. If you live in the province of Quebec and you make a designation in favor of a spouse, there are circumstances where those designations can become irrevocable, and you have to speak to a lawyer in your home jurisdiction to better understand that. But broadly speaking, capacity equals ability to change. Fourth point, powers of attorney documents are very powerful. They're incredibly useful, but as I say, they're also potentially incredibly dangerous. They can be used against you by a person who is an unscrupulous rogue, and they can really harm vulnerable and even not just vulnerable, but well-meaning people. So once you make those documents, please do take good care of them and make sure you've chosen your attorneys wisely. Final point is just as all of you, all in the artistic community, can make what you do look effortless, but you know the amount of experience, skill, and knowledge that's gone into it. Lawyers and notaries bring the same thing to the table. And the process can look very easy, such that some people think that you can sell a template for $100 on the internet and it's good to go. I'm not going to specifically say, get out there and retain a lawyer tomorrow, but I am going to say, don't underestimate the value of getting good advice and making a thorough plan that is specific to the facts of your situation and your family context, and that works in your home jurisdiction. By all means, seek out advice of a lawyer in your home province who can help you through this if you think that, or a notary, if you think that that's the right thing for you. So those are my remarks. I don't know if I went long on what I had promised, Scott, but there we go. So I look forward to Mr. Bain's presentation. Thank you very much.
Thank you, Kevin. No, that was great. I mean, a lot of stuff there. So I don't want you to go through it in 2 seconds and say, it'll be fine. Okay. Thank you, Kevin. Our second presenter is a partner in the Intellectual Property Division of Dickinson Wright. He is actively involved in the protection and enforcement of the rights of creators, writers, artists, photographers, film and TV producers, and musicians. He's a leading art lawyer, trusted advisor to artists, public and private galleries, museums, auction houses, philanthropists, and collectors on a wide variety of issues, transactions, and disputes that arise in the art world. Please welcome Paul Bain.
Thank you, Scott, for inviting me. Scott is a tough act to follow. He's got a really good voice. I think he should strongly consider a career in radio.
Guess what?
Yes,
been there, done that, still do.
I know. Zoom presentation number 1 zillion or so since the world changed in 2020. Still staring into the void a bit. It's hard to tell if my corny jokes are landing, but into the void, a fitting metaphor given today's topic. Copyright, quite literally, is something that will outlive you, outlive us all. We'll try to keep it brief. I forget what if we have a hard stop here, Scott, 2 o'clock, but I will leave ample time for questions and answers. So without further ado, copyright is an area near and dear to my heart. Slide 2, please. And I have this favorite artwork of mine by General Idea, which has been hanging in my office for about a decade or so. Copyright is something that's in the news. If you saw last week's Warhol decision of the US Supreme Court. And with all the talk these days about AI, NFTs and the like, it's a complicated area. And the technology, as always, is moving a lot more quickly than the law's ability to keep up with it is. Anyway, so I'm going to give a kind of an overview, refresher of what you need to know about the law as it stands in Canada when it comes to copyright and what may be coming down the pike. Or is it pipe? I never knew. Pike, I think. So when we talk about copyright, what are we actually talking about? It's often referred to as a bundle of rights, not just one thing. It gives the holder the exclusive right to produce, reproduce, perform, communicate, publish work, or authorize other people to do any of those things. A key concept when we're talking about copyright is originality. Now, not in the sense that you might think, but the idea is that it can't be copied from another work, but its originality is a pretty low bar, I would say. Something that's merely information is not protected, so you can copy the phone book or the periodic table, but as long as some kind of skill and judgment is provided by the creator, then copyright will pertain. So when I say it can't be a copy of something else, a photographer can go into a museum and take photos of an exhibition there, and that new photograph becomes a new work that's protected by copyright. Copyright Act in Canada, I'll just call it the Act from here on in, grants first ownership of copyright to the artist or author. However, if you create something as an employee, then your employer will be the copyright owner. The one exception to that rule is that as of 2012, photographers are the first owners of copyright, even if they've been commissioned by an employer or, let's say, a party at a wedding. And credit goes to CAPEC, for lobbying for that change. Otherwise, unless you transfer your copyright in writing, you will retain ownership of copyright always. Well, not always. We'll get there in a second. And your estate will, of course. Next slide, please, number 3. So one important concept to remember, and I tell people this almost every day, is that ideas are not protected. Only the expression of the idea is protected by copyright. And this is something that the artist Malcolm Raines found out the hard way when he sued the Romanian artist who was new to Canada, set up shop in Yorkville near Raines's gallery, and started painting. You could say he was plagiarizing Raines's well-known crumpled paper paintings. So you see the two here, kind of indistinguishable. And the court decided there was no infringement, despite the obvious similarities, because, in their words, it would be unfair to give Raines a monopoly over the idea of crumpled paper paintings, merely because he did it first. So not sure I agree with that decision at all, but there you have it. No copyright in ideas. They just float in the ether. Copyright, it's good to remember, is actually part of international law and something called the Berne Convention, which Canada signed on to in 1923. So happy copyright centenary, Canada. Berne, the treaty mandates that copyright is automatic. And it's meant to be frictionless. That is, as easy as possible for creators. What we mean by that is artists don't have to actually do anything other than, of course, to create their creation. Slide 4, please. Fixation. Now, we're not talking Freud here. Fixation is a key element of copyright. It's not the moment of inspiration that counts. It's not the idea, as I just explained, but it's the moment a work is painted on the canvas or chiseled out of marble or developed in a darkroom or on Photoshop. At that point, when it's fixed in a material form, copyright pertains or sticks. It's a sticky concept. Once there's a physical manifestation of the work. So we have the interesting artist Tino Sehgal here, who I've this photograph of his what he calls temporary situations. He hires actors in museum settings, but forbids images, catalogs. There's no writings about them. So the question arises, since there's no fixation, as to whether or not copyright would pertain to his work. Perhaps not. Anyway, here's a secret picture of his installation at the AGO a few years ago. Lawyers do this. They raise the idea of hard cases, which make difficult law. But in this case, it illustrates the point that you have to have fixation or there's no copyright. So what rights does copyright actually grant to the holder? For visual artists in Canada, and thank you very much to CARFAC for their advocacy in this regard, the exhibition right is something unique in Canada. And they had a well-publicized fight with the National Gallery of Canada on this very issue. Public institutions in Canada, museums and the like, can only exhibit works if they have a license to do that. And that is not the case in America, let's say. So, and this applies to any work that's been created after 1988. Private galleries, commercial spaces aren't subject to this exhibition right. And the important flip side of the exhibition right is the right to be compensated. And CARFAC, again, has fought the good fight to institute minimum standard exhibition fees, as many of you probably know, and most institutions are thankfully following this guideline. Moral rights, another very important aspect of copyright law, which you, your executors, your states need to know about. Also derived from Europe, from French law. Slide 5, if we could, please, Scott. So the Copyright Act provides 3 distinct aspects of moral rights. The first, probably the most important, definitely the most important one, is the so-called right of integrity. And this is the right to prevent distortion, mutilation, or modification of the work that would prejudice the honor or reputation of the author. And illustrated here is the Michael Snow work entitled Flight Stop at the Eaton Center, 60 geese. In 1982, the Eaton Center thought it would be a good idea to put Christmas bows on the, in a festive way, on Michael's sculpture. Michael took a pretty dim view of this, I would say, and sued the Eaton Center and was successful. So he applied. Well, there was a long letter writing campaign to get them to stop. Eaton Center refused. He sued them, filed an emergency application on a Friday. The judge ruled, and over the weekend, next slide, please. The Eaton Center had performed, I guess, you call it a bowectomy, removing the offending bows from Michael Snow's sculptures so that they were open for business, bowless on the next Monday. So, sorry, the other two important aspects of moral rights to mention are the right of attribution. So if your work is reproduced or used by another party, they must name you. But also the flip side of the right of attribution is the right to remain anonymous or pseudonymous, as Mr. Banksy has found out can be good for your career. And the third aspect of moral rights is the right of association, which is the right to control the use of your work in association with a product, service, cause, or institution. And we've seen this play out a lot when politicians use performer songs, and you end up being associated for the performer with a cause that you might not agree with, or a politician. We know that Donald Trump in his campaigns received a lot of cease and desist letters to say, stop using my song. This is an important point. Unlike copyright, the economic part of copyright, moral rights can never be assigned. You can't sell them, you can't transfer them. They go everywhere that you go, and again, they will outlive you. They can be waived, however, which means you can agree in a contract not to enforce your moral rights, and that's something we see a lot in public art commissions. Slide 6, please. Important question given the topic today: how long does copyright last? As I've said, protection arises from the moment an original work is created. The term of copyright is now 70 years. Until last year, it was 50 years. So it's been bumped up by 20 as a result of the free trade NAFTA negotiations to coincide with what America does. Mexico, by the way, has a 100-year term for copyright, which I guess is good if you're Frida Kahlo in her estate. So just to restate, moral rights and copyright have the same term, 70 years. Once that term expires, your exclusive rights as an artist end, and the work enters the so-called dreaded public domain. So for instance, slide 7, if I could, or I guess that was slide 6, Lauren Harris's work from the Group of Seven, who died in 1970, passed into the public domain at the end of 2020. At that time, it was a 50-year term. And the concept of public domain, yes, slide 7, explains the proliferation of these immersive art shows, which we see everywhere. Because in the case of immersive Van Gogh or immersive Monet, there is no estate to have to pay since they are long gone. Slide 8. So just to spell it right out, if any of you have the bad fortune to be hit by a bus tomorrow, in December 2093, your works will be available to the whole world, or maybe the whole solar system, since at that point we may be living on Mars with Elon Musk's many descendants. Yeah, jokes that don't land, I don't know, but hopefully someone's laughing out there. Okay, moving along. As lawyers often say, rights have no meaning. They're pretty useless without remedies. So how is copyright protected and enforced? What are the remedies? In Canada, it is possible to register your copyrights, even though, as we've seen by international law, copyright is automatic. Registration can be a good idea in the context of litigation if you know you have to sue someone or are being sued. As a defensive mechanism, it avoids, the registration avoids having to prove having to prove that you own a work, or that, or the date upon which it was made. So for $50, you get a certificate of copyright. But again, not a lot of utility, and it can add up if you have, hundreds of works in your estate to worry about. Although if you have books published with many, many images, you can get around that by publishing the entire, by registering the entire book, which has the advantage of, in one fell swoop, getting protection, or at least registration for all the images in the book. The main way, though, that copyright is protected is through legal enforcement. Copyright is what is known as a negative right. It gives you the ability to tell others to stop. And we call this infringement. Infringement happens when any person does something that only the copyright owner is entitled to do under the Copyright Act without permission. And the same applies to infringements of moral rights, which is actionable separately from any infringement of copyright. And as we saw in Michael Snow's case, he sued only for moral rights infringement. It wasn't about money or anything else. Slide 9, please. So penalties for infringement, if you're able to stop someone from doing this, can include monetary damages of up to $20,000 for each work infringed, injunctive relief, in other words, a court ordering someone to stop, damages if someone is, let's say printing thousands of t-shirts, you can go after them and have them account for all the sales to you. And there's a delivery up option, which is a court order requiring the offender to deliver up the offending material for destruction. You get these offending t-shirts returned and you have a big bonfire, or do with them as you may. Now, not every use of a copyrighted work amounts to infringement. For one thing, there must be a substantial part used of the original. And what is substantial is a matter of interpretation. It depends more on quality than quantity. So if it's a key part of a work, then you're looking at infringement. But it may even be a small part. For instance, a few notes of a song, if it's the catchy part or the hook, then that is probably infringement. So in other words, partial use of a work may still involve infringement if that portion constitutes a substantial part of the original. And again, to emphasize, what is substantial is a matter of degree and context. So the facts matter in each case. As of 2012, Canada modernized, we thought, our copyright law, and they enacted a whole bunch of exceptions to infringement. One of them is the so-called YouTube exception, which allows people for personal reasons, non-commercial gain, to do a mashup in a video. They can take videos or different things that are protected by copyright, as long as it's for a personal kind of use. In that case, no consent is required and there's no prospect of infringement. Slide 10, if I may. The most important aspect of infringement that was codified in the law in that same 2012 amendment to the Copyright Act is under the rubric of fair dealing. So fair dealing simply is that there are certain allowable purposes which take something out of infringement. And those allowable purposes are as follows: research, private study, education, parody, satire, criticism, review, Obviously, someone reproducing something to criticize it or review it in the paper or in a blog, no infringement there. Sorry, that's 7, and news reporting is the final piece of that puzzle. 8 allowable purposes, which we call fair use. Fair dealing, I should say, sorry. Fair use, slide 11. I would be remiss if I didn't at least mention the Goldsmith and Warhol case, which came out last week on this issue of fair use. The Supreme Court ruled, and leave it to them to screw things up as they have in many other areas of law. And this ruling really shocked the art world. They decided that Warhol's use of a photograph of the musician Prince was not fair. It was not transformational in the term of art used. It's hard to believe that Warhol, if Andy Warhol's work is not transformational, it's hard to know what really is. So no word yet on whether the Campbell Soup Company will file suit against the Warhol estate. But in all seriousness, I think it's not a good decision for artists who show in the US. Justice Kagan, in a very brilliant dissent, which I think you should read if you get a chance, called it an anti-art decision, which will stifle creativity and make our world poorer. Okay, there is some good news on the horizon for artists and estates. Slide 12, please. Resale rights for visual artists. So resale rights are a type of royalty payment paid to visual artists each time their work is resold publicly. And in theory, this would go on in perpetuity. Musicians, writers, other artists, after all, get a payment every time their work is used or sold. So why should it be any different for visual artists? Resale rights protect artists from exploitation by commercial secondary markets. And like copyright, resale rights generally continue after an artist's death and become an asset of his or her estate. Slide 13, please. So what is the current state of play for resale rights? Currently, artists in Canada don't have any method of receiving income from the growth in value of their artwork over time, which is pretty unfair. We have the tragic case of Matthew Wong, a painter from Edmonton, whose paintings were selling for thousands of dollars. After his death, tragically by suicide in 2019, prices skyrocketed at auction to several million. So the question arises, why shouldn't his family, his heirs, see anything from that rise in value on the secondary market? 90 countries around the world have 90 countries around the globe have recognized resale rights. So Canada is a bit of an outlier in this regard. Even California has it, although not in the rest of America. The specific proposal, and again, Carfax deserves a lot of credit here, is that artists would receive 5% of the resale value on any secondary sale at auction or at a gallery over $1,000 in value. And so far, the bill to amend the Copyright Act and add resale royalties hasn't been introduced in Parliament. The Senator Pat Bovey was a champion of this, and she retired just May 15th. But I spoke to her and she assures me that it is a matter of if and not when this becomes law. So here is hoping. Okay, just to wrap up, every 5 years, copyright law in Canada is reviewed. And in 2019, in a report to Parliament, the Standing Committee observed the following, which I will leave you with. There is a disparity between the value of creative content enjoyed by consumers and the revenues received by artists in creative industries. And this value gap is growing. The reason for this gap is outdated and ineffective copyright legislation that diverts wealth from creators to large digital intermediaries and platforms. through which artistic content is consumed. That, in a nutshell, is the problem. I hope we're working on it. Good luck to everyone. Thank you.
Thank you, Paul Bain. Okay, lots to talk about. We've had quite a few questions, and I had one submitted. And Kevin, if you want to join us as well, we had one submitted early, and I know this is a big one. A lot of people are going to be wondering about this. Marlene Kreitz wrote that she has more than 50 bankers boxes constituting the sum total of her life's work. They include teaching and workshops, artist statements, correspondence, live art events, many other things. When she donates this to a public archive, such as the university or the National Gallery of Canada, will the value of this be subject to capital gains tax? And I know this is a big issue for a lot of artists, especially visual artists.
So I don't know if Kevin wants to address that, but I know a bit about this. The way to avoid cap gains on property that you donate to an institution is to donate it through the cultural property regime. The Cultural Property Board is a body of 10 that meets periodically, and if your work is deemed of outstanding significance, and there are rules around this, then and certified by this board, and the museum or institution, say it's a university, champions it, then you will get a certificate of cultural property and pay no capital gains on whatever the value is. So it's a big advantage to donate your archive if you can through this process.
Kevin, anything to add?
Nothing at all.
No, you're muted. Oh, you're unmuted now.
Yeah, no, that's
Actually, you weren't coming through. I think you're breaking up their audio, Kevin. Seem to be okay now, though.
Nothing to add.
Okay, good. Thank you. What about the ongoing question of a visual artist's work when they die? How is that valued, and is there capital gains tax to be paid on that? Paul, Kevin?
I mean, it depends probably on a number of factors, which are probably specific to the circumstances. Like, I mean, if it's the value of the asset at the time of death is really a tax question that relates to the estate administration. That might there could be probably a number of different circumstances where one way or another it could be a gain. But typically, to trigger a tax liability in an estate, there has to be an acquisition and a distribution. But I wouldn't want to wade into it and give a general answer, because I'm not sure that I'd be right. I'm not an estate administrator. I don't know. Mr. Bain?
You're muted, Paul.
Talk to your accountants always.
Simple, well, not a simple answer necessarily, but a short answer. Thank you. A question from Leah Murray. If we assign rights to our heirs and successors in our will for copyrighted works, does that prevent the work from going into public domain?
It does not. No, the term of copyright will remain 70 years after death.
Okay. Suzanne wants to know, an actor who has incorporated, can they dissolve the corporation and the implications of the corporation passing on to survivors or successors? Can you comment on that?
Well, I mean, a corporation is a living entity.
Kevin,
and can you hear me?
Yes.
Yeah, corporation's a living entity. You know, they can outlive a natural life. If you have to take advice from a lawyer who understands the corporate law implications, there could be tax implications. But oftentimes I would just say that corporations are used as vehicles to ensure continuity of assets outside of a natural life. So, you can sell, or you can give away the ownership of a corporation and the assets that it holds to another person, sometimes as part of an estate plan. But again, that's a very fact-specific question that you'd have to get professional advice on.
Okay, Paul, anything to add? Okay.
Sorry, I agree.
Okay, good. Celia asks, she says she's come across people reading her books online without permission. Is that a violation of copyright?
Reading the book would not, no, I don't think there's any way to enforce that. It's whoever is posting it, if it's unauthorized, then that would be a problem. I don't think the mere act of reading is any kind of violation, no.
But it sounds like it's without the author's permission.
Well, whoever's putting it up there would have to answer some questions.
Okay.
The publishing it without permission is the problem. That's the violation. The reading of it, no.
Here's a question that applies to, I know, performing artists. Is it necessary to specify works that are entitled to royalties in your will? For example, I did some singing on a TV movie of The Music Man many years ago, just in the studio, and I got a royalty payment recently for 4 cents. And I want to make sure my successors still benefit from that after I'm gone. Does that have to be specifically spelled out?
I mean, generally, no. Usually wills give away a few specific things and then leave most things in what we call the residue. And the residue is sort of the catch-all for all the other bits and pieces of property or assets. And then that residue is split up amongst beneficiaries that you've chosen. What I would say is that, like many things, it's not an issue in the will itself, but it's an issue in the estate planning and in the estate administration. Because what we see quite often here at AFBS is people will have residuals that go on forever. Their commercial still being played years after their death, or their show is being replayed, and residuals are flowing in. And the executors and the beneficiaries are simply unaware of the operation of that perpetual payment. So they fall out of touch, and there's no specificity to it. So I would say what's important is that when you sit down to draft the will, you inform the lawyer that you have this potentially perpetual stream of payments, where they will be received. So in the case of Canadian performing artists, it's usually through the Performing Rights Society at ACTRA, but we also get a small share of them coming into AFBS. So you need to signpost that for the people who will come after you who might not know this. Key piece of information, but the answer is it can be dealt with as long as you remember to tell someone.
All right, thank you, Kevin. I may have asked this already. This question may be related or same. Tell me if it is the same. Can you speak to the income tax burden on heirs who inherit a professional artist's unsold artworks? Paul, do you want to?
Well, again, not an accountant or a tax lawyer. But there's no, well, Kevin knows this, there's no inheritance tax per se, right? It's only you have to file a final tax return for the deceased. Is there a deemed disposition, Kevin, of all assets? I don't think so.
No, I don't think so. I mean, I guess we'll go into the estate valuation for the purposes of the estate's administration fee, which is charged in Ontario, certainly. I think a lot of it would come down to noted valuations in that respect. But if there's been no distribution, or there are certain taxy things about tools and business related things, but I would think a work would be more of a settled asset. So again, a question that you'd have to ask a lawyer who's versed in the actual tax implications of administration. But my instinct is no. But you need to get accountant's eye view of that.
Okay, so for anything financial, would that be a good idea? Get either a tax lawyer or an accountant's advice?
Yeah, I mean, a lawyer who is actively dealing with estates administration probably knows most of the sort of the Coles Notes level of the tax implications of most distributions and retentions. Where there are more complex questions that might be complex because they're very industry specific or artistic community specific, or because they're very high value. A good lawyer will usually bring a tax accountant in to give opinions on it, because there, as you can imagine, reams and reams of interpretation bulletins that come out of the Canada Revenue Agency that deal with a remarkable amount of minutiae. So nobody wants to be an amateur in that space.
Celia asks, if I wish to change my POA, how do I do this? Do I need a new will?
No, the two are separate documents dealing with separate things. So powers of attorney deal with designations during your lifetime, and wills deal with things after your death. If you want to change a power of attorney, then you should make a new power of attorney revoking the old one. Is probably the best advice that's probably applicable in virtually all jurisdictions. But you should speak to somebody about that in order to revoke or do away with an old one. The traditional way is simply to rip it up, but in days of photocopies and electronic transmission, that's not as thorough as you might like. So make a new one, revoke the old one.
Question on copywriting music. A performer who performs in a concert with original material, and the song that he or she is performing is an original composition. The show may be recorded and sold. How do they guarantee their rights? Should they register the song for copyright? And a secondary question to that is, I understand that copywriting a song in Canada just involves registering the title, not the lyrics. Is that correct? Paul, do you want to?
Well, again, copyright arises irrespective of whether you register it or not. In terms of performance rights, most performers register with SOCAN, who collects, every time a song's played on the radio, the performer gets a royalty through SOCAN for that performance. So the best way to protect your rights in performances is to register with SOCAN for the song lyrics included.
Question on executors. Is it advisable to ask one of my 3 adult children to be an executor, or could 2 of them, or could I ask 2 of them, or should it be all 3?
Well, that's a good question. It's a very personal decision based upon trust, based on the nature of the relationship, based upon the future implications of them relating to each other. If one's in, one's out, those are all questions that you can only answer yourself. What I can tell you is that it's very common to appoint joint executors. And sometimes it's really quite a sensible thing to do, because there may be offsetting skill sets where they can help you, particularly when you're appointing people who are intimate family members, they're going to be upset when they have to deal with the aftermath of a loved one's death. And if they can work well together in order to help each other out in that regard, it's a great idea. So is law, the drafting solicitor, the drafting lawyer can give you tips about that dynamics in a specific way. But as long as it's not an unworkably large crew, I think 3 would be the maximum. There's usually not an objection to it. And it may be quite a good idea.
And I noticed someone asked about whether it's a good idea to have one executor deal with the art. And I think that is a good idea, someone who's knowledgeable or knows the museums or understands the art practice. So I think that's good advice.
And I would add to that, I would echo that, and I would add to that, that that's one of the challenges we find oftentimes in dealing with executors of estates that have something unique about them. You know, a collector's estate or an artist's estate, because you know the executor whom you trust, you know, your brother-in-law, might not know anything about the uniqueness of the objects in the estate or the dynamics that underlie it. So that kind of specialty knowledge is often really helpful. And if you can get it in your executor, so much the better.
Okay. We've pretty much run out of time. Any final thoughts, final words, final things to share from either of you? Kevin, Paul?
I'd just like to express my thanks to you, Scott, and to Paul, and to everyone who attended today. I really appreciate the opportunity to talk about these important things.
Me too. Agreed. Yes.
Before we go, I want to thank Patrick Close for his advice in framing the topics for today's webinar. Thanks also to AFBS, CARFAC, the Canadian Federation of Musicians, PAL Ottawa, and everybody else who helped to spread the word. And most of all, thank you for showing up today, because without you, this whole exercise would have been pointless. So take care, be well, have a creative day, and we will talk again.